All right, again, this is Shawn Eyestone. We are here to talk about the IRA Preservation Trust. We have a few people on the webinar, plus there's going to be some others that will be attending via the recording that we will post to our website shortly. We are coming up on the holiday weekend, so I understand that some people are out of town and would prefer to listen to this on recording. So if you do catch this on the recording, please feel free to send us questions either through the website itself, or if you want to email us at info@eyestonelawoffices.com. Again, that's info@eyestonelawoffices.com. We would be very happy to answer those questions. So let's begin. First, I'd like to begin with a disclosure and legal disclaimer because I am a lawyer and that's what lawyers do. The first thing that I do not recommend any investments or insurance products. So you don't have to worry about that. You can keep listening if you've already got those taken care of. I am not receiving any payment or commissions from or for any investment products or insurance. This meeting and webinar discussion is for educational purposes only and is not nor should be construed as any legal advice. The one last disclaimer that is up here is that we are recording this, and if you do have questions, there is a chat link you can use to remain somewhat anonymous. It looks like everybody on the call either has an anonymous name or just a first name. So anything you do post will be visible to other folks on the call. And I would just advise you of that and that we are recording this. Right now I do have everybody on mute, but I will take that mute off at the end if anybody would like to speak their question instead of type it in. I think you just hit *6 and it will let me know that you have a question that you would like to speak over the webinar here. So continuing on, I want to talk about why people love their estate planning attorneys. And it's not just because we're wonderful people that everybody's just banging down the door to see us. We're smart, we're good looking. Well, actually, people are not always banging down the door to come see us. It's a lot of times it's like pulling teeth. People want to come see an estate planning attorney about as often as they want to come see the funeral director. But it does make things easier for both you and your family members by working with an estate planning attorney. People love us because we help you control your property while you're alive and doing well. We help you plan for yourself and loved ones if you become incapacitated. We also help you give what you have to whom you want, how you want, and when you want, whether this is while you're still living and want to give things away in an informed manner to make sure it doesn't interfere with any other benefits or other issues that may arise, or after you're gone, if you want to leave a legacy. And our program is called Infinite Legacy Planning, so we help people plan for infinity, and your definition of infinity is whatever you'd like it to be. As long as you'd like to plan for, we can help you do that. So today we're talking about IRAs. Chances are, if you're on the call, you have an IRA, and by having an IRA, you have made a series of very wise decisions over a long period of time. Many people start IRAs when they are later in life. Lesser number of people start them when they're younger. A lot of people will have a 401k program, which is a type of retirement account that employers will match. and eventually those can be rolled over into an individual retirement account as well. But there have been some changes in the law, and these changes give us an opportunity to take action to protect and preserve what you've worked so hard to save, and to make the best use of it for the generations to come, and also while you're alive to make the best use for it as well. So some of these could literally make or break your IRA. So for estate planning purposes, your biggest problem asset could be your IRA. So even though you've taken all of this time and effort and made all of these sacrifices to put this money aside into an IRA or a 401k, it could cause you some problems for estate planning purposes. And before I get too far, let's talk about what I'm referring to when I'm talking about IRAs on this webinar. First, it includes traditional IRAs. So these are the individual retirement accounts that you can set up with various brokerage or other firms. Banks offer IRAs as well. There are also Roth IRAs, and these are the after-tax dollar IRAs, where you can either roll over your existing IRA into a Roth IRA and pay a pretty decent sized tax bill in 1 year, or you just make the contributions with your after-tax dollar, so you do not get a tax deduction for deposits to Roth IRAs. And we're also including the 401k, 457, 403b, and other corporate retirement plans. And the IRA program has had many changes over the past 40 years, and I'll focus on a few here. Back in 1975, the plain vanilla IRA was created. The other great thing about 1975 was that I was created. That was the year I was born, so I've been around as long as IRAs. Most people did not start an IRA in 1975 because many people still had pensions and other benefits that employers were providing back then, but it was the beginning of the IRA law. And then from 1975 to 2002, there wasn't much going on in the world of IRAs. People were starting them, they were investing, people were retiring, they're having benefits paid out, and they could take the benefits over their lifetime. And there's actually a few tables on how you can figure out what your benefits are over your lifetime, whether it's your own IRA or an inherited IRA. And also, 1975 to 2002, there wasn't much going on in my life. I was being raised and born, and I went to Western, and then I went to Wayne State. I got my first job, and just as I get my first job, 4 or 5 months later, in April of 2002, the stretch IRA concept was born, but it left some uncertainty about how a trust could be used to implement the benefits and protections of a stretch IRA. And this is something that still lingers around, where we get a lot of financial advisors who, for their whole careers, have had it pounded into their head to never, ever make an IRA or a 401k beneficiary designation to a trust. Because if you do, there's all of these horrible tax consequences that can occur. And the truth of the matter is, if you do it wrong, there are lots of horrible tax consequences that can occur. And the How to Do It Right came out 2004, 2005, 2006. There's many different revenue rulings, private letter rulings that were issued to clarify how a revocable trust can qualify as a designated beneficiary under an IRA plan. And we'll talk about some of these ways. Now, in June of last year, 2014, stretch IRAs that are owned by certain trusts are creditor protected, whereas stretch IRAs owned by individuals will not have that same protection. And again, the U.S. Supreme Court made this decision last June, about a year ago, and what they found was that the laws that states use to protect your retirement funds from creditors reaching them do not apply if you have inherited this IRA from a parent or someone else. The reason being is that it is not your individual retirement account at that point. You are just merely a beneficiary. You did not save this fund for your retirement, so these laws that were created by the individual states are not going to apply. This was a bankruptcy case that found that someone who was filing for bankruptcy but had been named a beneficiary of a stretch IRA could be forced to take all of the distributions to satisfy the creditors. However, the court did say that if a trust was a beneficiary and limited whether a person could take out any funds from that trust, then they would honor that creditor protection within the trust. So in the intervening year, since this ruling came out, I've attended lots of training and talked with lots of other lawyers and also with clients and other advisors about this concept of using a trust now to utilize the stretch IRA benefits. And the more you think about, or the more I thought about, and other attorneys talked to me about this concept of using a stretch by means of a trust, there's lots of intriguing things and lots of great benefits that you can pass on. So some of the issues with a trust, or an IRA for that matter, is that if you don't do things correctly and you don't give the money away correctly, people receiving the money can pay a lot more taxes than they need to do. Right now, the federal income tax rate, top rate 39.6%, Michigan income tax rate 4.25%. The federal estate tax rate is up to 40%, and the state inheritance tax can be up to 10%. Now, Michigan does not have a state inheritance tax, but the inheritance tax that would apply if you moved or to some of your children could be upwards of 10%. So the main reason of showing these numbers is that it's very easy to get your inheritance taxed away. So what can we do to help people to make educated decisions about using these retirement funds? The beneficiaries, what can we do to have them avoid taking it all out in a lump sum, paying that 39 plus percent tax rate? We give them a little carrot on a stick. And, even without any federal estate tax and out any inheritance tax, the federal and state taxes can still come up over 40%. And by doing that, for every $100,000 of your IRA that you leave to Jimmy or Susie, maybe they only get 60,000, and you lose all of that growth that in income that you've accumulated over the years, and they've got to basically start over. But what if you could get $100,000 instead passed through? What if you can get almost 6 times that, 590,000? 1.22 million. Could you imagine what your family could do if they had those funds and you could ensure that they had them? With a trust, we can do that. We can force people to take out the money into a stretch, and it would also provide better protection against bankruptcy, lawsuits, divorces, creditors, and they don't have to make a decision about it. The facts and figures and studies that I've seen over the years have said that within the first 9 months of receiving an inheritance, people, beneficiaries, will have used 80% of their inheritance. And if you think about that, it's not just taking the money and going gambling in Vegas that they're doing. By using the inheritance, we're saying that it becomes um, commingled with other assets that they have. They use it to pay off bills. They use it to pay down a mortgage, which is commingling. They put it into a joint account with their spouse, which means that if there's a divorce, it's going to be very difficult for them to get any of that inheritance back. And another study that I've been told of says within 18 months, all of the money is gone. All of it has been absorbed into the various family members' own personal budgets, and it's indistinguishable at that point as an inheritance. So, and this applies to money, not so much with real estate, but with these IRAs. For most people, nearly 100% of the funds have been cleaned out after these 18 months. So, what can we do? As planners and as family members, there's two concepts that we would like to do. We'd like to help with the stretch out and the protection of these IRAs. And for people who have a significant amount of money in the IRAs, with a lot of these companies who have moved over to 401ks or 403bs, the generation that's coming up on retirement or heading into retirement right now has a whole lot more in these qualified accounts than has ever been before in our history. But there's a warning that we as planners want to tell to people who have these accounts that assume that there's going to be this stretch out and the families are only going to take the required minimum distributions and they're going to be good stewards of the money and not pay too much taxes. The stretch out is not automatic. There are um, some new RMD, this is the required minimum distribution rules for longer income tax free compounding, that the assets can grow more after you're gone. Generally, a beneficiary can use his or her own life expectancy and the power of income tax-free compounding, and then this rule of 72, which at 7% annual growth, an asset doubles every 10 years. So if you think about that and you think about the tax rates, this income tax deferral can go for a long period of time. However, you should also know that your IRA will outlive you. The required minimum distributions are not going to be entirely spent down from your IRA during your lifetime. So if you look at the rules for these, at age 70 and a half, the required minimum distributions say that you're going to have 27.4 years of distribution. So the first year is less than 1/27th of the fund, which is less than 4%. So even at a 7% rate of growth, your IRA still is going to be growing. So if you look at this chart and you look at the amount of life expectancy, the longer you have to live, the more gross distribution there is going to be remaining. So if you have a 10-year-old with a remaining life expectancy of 72.8 years, this $100,000 can turn into nearly $3 million. And why is that important? If you have a husband and a wife, 70 and a half and 68, with $300,000 in their IRA, even by taking out all of their RMDs, they will still have over $400,000 at the end of their life expectancies. And people are living beyond these life expectancies. If they've made it to 70 and a half or 68, chances are they're going to make it into their 80s or 90s. So if they had this over $400,000 and they left it to that 10-year-old that I mentioned before, that was a grandchild in an IRA preservation trust that was set up, this trust would ultimately pay out over $5 million over that life expectancy of that 10-year-old. It's an annuity that would continue for his whole life. Even after paying taxes at today's rate on those RMDs, he's still looking at $3.7 million in benefit from that $400,000. And every year, he's going to get a piece of that $300,000 that becomes over 10 times that over his lifetime. And it's a huge asset. And you know what else it is? It is a grandma and grandpa loved you, so they put this money aside for you, and they're going to think of grandma and grandpa and what a wonderful thing that they did for them, that they have this check every year or every month or however often it's distributed. They're going to remember that this is where it came from. It came from grandma and grandpa because they were planning ahead, and it's going to instill those values in these children as well, that they appreciated that type of giving and thoughtfulness by their grandparents, and they're more likely to be better stewards of their funds as well and set up something similar for their children and grandchildren. Here is a very fancy chart. The main purpose of this chart is to show you that I'm capable of making very fancy charts. Um, in addition to that, there's a sample client is the client's name. So this shows how the IRAs can flow. So typically what happens if sample client dies before his spouse, it's going to roll over to the spouse. He can either have it roll completely over to the spouse, or he can split it between the spouse and the children. And if he doesn't survive the spouse, then it would get split between the children into their separate, what's called a conduit trusts. So by naming your spouse first, your spouse then has the ability to roll over your IRA into his or her IRA. And then if they have a protection trust, the spouse's beneficiary is already in place as well. So if you name your trust as the contingent beneficiary and and your spouse goes first, then the trust would get those funds. And then this shows the same thing from the spouse's perspective, which is, it's really the same thing in reverse, that, regardless of who is the beneficiary of the trust, you can use the, potentially you can use the same trust for both spouses if you use that rollover example. And by using this stretch, you create this huge asset for your family members, and this IRA that for a lot of people exceeds their value of their home, contents, vehicles, everything, life insurance, everything combined, it can become a huge asset for everyone. Now, we do have some language in our basic living trust that does sort of the conduit situation that we can do with an IRA trust, but it's pretty complicated planning, and it is difficult to make the living trust live up to all of the requirements of the Treasury regulations. When we draft them, they are all ready to go in that regard. However, over time, some of these requirements can't be met. Usually, always, our trust is valid under the state law. The trust always becomes irrevocable at death, meaning it cannot be changed. And for some trusts, this is not the case. There's quite a few joint trusts that people started drafting after the estate tax exemption amount went way up. And a lot of these joint trusts that I see don't become irrevocable at the death. And if they are named beneficiary for part of an estate, and I've seen this situation where the trust is set up for, maybe it's a remarriage situation, so the stepmom gets some of the funds and then the children get some of the funds, and the funds are held in trust. Now, the fact that the children are on there typically makes it so part of the trust isn't irrevocable. And where a lot of people will get tripped up is changes to the beneficiary designations aren't made out correctly, or they're just overly confusing because the language of a joint trust is just very difficult to follow because they're trying to save on words and pages, and it makes it difficult to ensure that the trust is irrevocable. I have trusts that I'm administering that other lawyers have drafted where there are opinion letters where I'll get competing opinion letters from a tax attorney and from another trust attorney just to see if we can get two people to agree. And when two people can't agree that the trust does what the trust says it does, there's going to be a huge risk that it's going to be in violation of these Treasury regulations. And by having a separate trust, it's much more streamlined and easier to allocate the assets between the retirement assets and the non-retirement assets and put all of these hoops in that need to be followed and jumped through for these Treasury regulations in these retirement trusts. So the other issue that we have is the trust documents have to be provided to the plan administrator by a certain date after the year of the participant's death, and a lot of times that is missed just because the trustee doesn't notice that they're supposed to be doing it, or they don't talk to the trust department, or they don't talk to an attorney until it's too late. And this can a lot of times be avoided with a retirement trust because the retirement trust would be provided initially to the plan administrator, so they would have a copy of trust before you died, even just like it would be your beneficiary designation. It doesn't have to have all of those other private things about your finances in it. It can be just limited to these retirement assets. And then the beneficiaries must be identifiable. And there's lots of different of these rulings from the IRS that talks about who's identifiable and who's not. But a designated beneficiary is not a charitable entity. I'm a member of the Grand Rapids Lions Club, and we've got a charities section. If I were to leave funds in my trust to the Grand Rapids charity or to my church or to the community foundation, and there was any way possible that the retirement funds could be turned over to these charitable entities, that automatically makes a whole trust in violation of these treasury regulations. And even non-charitable entities. So if you've got a business and you have some funds that you're going to be leaving behind for your business, or if you really do love your lawyer and you want to leave your lawyer's firm some money so you can have a nice party for his staff, or if the Lions Club, the non-charitable portion, any of these things is not a designated beneficiary. And another part that we're seeing much more lately is people who leave their pets or farm animals, a lot of times horses. Even if you have a horse whose name is IRA, you're not going to be able to leave any of your retirement account to them through a trust and get a stretch. So if there's any chance that any portion of the trust is going to end up there, it would be invalid. The last two here are the ones that come up the most. Your estate. If you don't have contingent beneficiaries clearly spelled out, or if the contingent beneficiary could be your estate or others' estates, which is possible, then the trust would be invalid. And an example of this is if somebody dies during the administration of the trust before everything is distributed to them, and there is not a clear description of who may get the asset after that person is gone, it will go to that person's estate, and all of the IRA protection, stretch protection, will be lost. And then people of the future, an individual born after a participant's death, unless they're properly designated. And sometimes there are designations that people will say, I want it to go to all of my grandchildren, even if they're born after my death. You just simply can't do that with an IRA designation and get stretch protection. They have to be living on the day that you die in order for that stretch to occur. And the other issue with not using a trust is that the individual beneficiaries may create lots of problems. They might not know of all of these rules and what their choices are, and the custodian may be asked what to do, and in response, they just get a check from the custodian. There may be a corporate plan that requires a payout in 1 year regardless of the rules, but they can still do a rollover if they follow the rules. And I guess if you set it up with the trust and have that rollover in effect and have an attorney look at your plan, you can take and roll that over and make sure that you're going to have the benefit of the stretch. Now, a lot of times the beneficiary will roll it over into his or her own IRA, which will also create problems, or the beneficiary or their spouse of another third party just wants to spend it. And that's really what happens most of the time, is they cash that in, don't really care about the tax consequences. People are happy 60% of something is better than whatever, what the if they have a 50-year life expectancy, then that would be 2%. So 60% is better than 2% in their mind, and they don't take the long view. And also, the trust is designed to provide protection against it being inherited by a minor child or a grandchild that would get a big lump sum or the ability to take a big lump sum on their 18th birthday. If there are children or grandchildren who have spending problems, creditor problems, drug, alcohol, other types of problems, and are considered to be a spendthrift, that they will make poor choices with the money, then there are provisions that can slow that down and stop them from spending the funds. And a lot of other family problems that we see involve a controlling or manipulative son-in-law or daughter-in-law that forces the um, hand of the beneficiary. The trust gives them the ability to say no. Say, no, I can't take it all out right now and buy a pool or buy a Lexus or buy you an 8-carat diamond ring. I simply can't. All we get is 1/50th per year, and I'm happy with that. And then they go along their merry way. And there's also unscrupulous people who try to influence vulnerable beneficiaries. And all beneficiaries are vulnerable. Most people are kind-hearted, and I don't know that I've ever met someone who hasn't been swindled by someone. Some are small, some are big. Maybe it's a friend who wants to go 50-50 in a business, and it sounds like a great business idea. I'm going to be the money guy, or you're going to be the money guy. I'm going to run everything, and you're going to get 50% of the profits. And then there's never any profits, and you ended up spending all your money on this business that failed. And then the last one here is if the spouse needs some nursing home care, losing those funds because they are available for paying for that nursing home care. Even if it is the spouse of the beneficiary, a portion of that is going to be reachable, and it's going to be forced to be paid down, except if it's in an IRA preservation trust. So the IRA preservation trust is just a vessel. It is if you think about it in its simplest terms, the IRA preservation trust is a breakthrough strategy in IRA planning, but it's a fully revocable trust which have been around for years and years and years that you can change anytime that you wish, and it's totally separate from your will or your living trust, so you don't have to plan them in tandem. You create it now to be the beneficiary of your own IRA. So even though it's the latest, greatest breakthrough strategy, etc., in IRA planning, it's really just a very detailed, complex beneficiary designation. It's instead of saying my beneficiary is my son, you say my beneficiary is the trust created for my son, and oh, by the way, here are these rules that he's going to follow when he uses it. So during your lifetime, you control this. You control the trust as the initial trustee. You and your spouse can be joint trustees, and it is through the trust in which your beneficiaries are going to receive your IRAs after your death. And again, it's really a very complex beneficiary designation, but it works. It has, and why does it work? What does it do? It's got this A-B switch. So a conduit trust is the trust that gets the specialized tax treatment that you get to use the stretch over your lifetime instead of having to cash out within 5 years. So the conduit trust is going to give you the best tax protection. But we have a trust protector who can come in and they can flip a switch. So if you have a spendthrift grandchild or child or other beneficiary, they can turn the switch and say, this isn't a conduit trust anymore, it's an accumulation trust. And then in those cases, that trustee and the trust protector will have made the decision that it is more important to protect some of these funds and pay the higher tax rate than have all of these funds be received by the beneficiary over their lifetime. And this is especially the case if there's a problem such as a drug or alcohol problem or other spendthrift issues where it becomes a detriment and maybe even deadly to the beneficiary to receive those funds. So it has that benefit in there. It's going to have better creditor and predator protection because they have an independent party that can help them say no. And it helps protect minor beneficiaries. So it'll help use the funds for college. It'll help use the funds in a smart way so that the minor beneficiaries don't just get a big lump sum at age 16 or age 21 or whatever age you can imagine in your head for a big lump sum. Very few people do well with big lump sums of money when they receive them. If you watch TV, there's these reality shows about people who win large amounts of money um, through lotteries or other things, and it ends up ruining their lives because they're surrounded by people that don't have money. So a lot of them will try to help people out, give money away, or they'll have big grand ideas of taking this money that they have and make it into more money and losing all of the money again that way, or they'll just live high on the hog, not realizing the sacrifices that were made for that money or the sacrifices that continue to need to be made to preserve those funds and use them in an orderly fashion. And for special needs beneficiaries, it preserves the ability to receive these government benefits. So if they're receiving government benefits, a lot of times an inheritance is the worst thing that they can get, because a lot of times an inheritance will cut off the benefits immediately. And then there's a gap period at the end when they requalify for benefits between when the money runs out in the bills and someone either has to pay that or they just keep getting more and more bills. So what is helpful is to have this trust that can coordinate with the government benefits so that they can receive the minimum care that the government provides, and then the trustee can add to that, augment that, and give them a better quality of life. And the trust will also ensure the proper distribution to the beneficiaries so that they do have that stretch out, that they are well cared for. And for married people, typically we still recommend that your spouse is the primary beneficiary. And then after the death of both the husband and spouse, the intended beneficiaries, whether it be grandchildren or children, will receive their distributions through this IRA preservation trust. So there's three choices. You can give your beneficiary designations to individuals and maybe you get a stretch out, maybe you get better protection. Well, maybe you get a stretch out, but you won't get better protection. And then with a living trust, um, maybe you can get a stretch out. It's not likely though, just because it's difficult for a trust to be drafted in that way. And I've seen very few attorneys who have been able to accomplish that for their clients through a living trust that's handling all of the assets. And there is a little bit better asset protection through the living trust than not. But with the separate IRA preservation trust, you can get this stretch out and you can get the better asset protection. And if you wanted to supersize your stretch, consider a Roth conversion. There's a very narrow time period, and your financial advisor and accountant would be able to tell you much more clearly than I would when that narrow band of time is. But typically, when you're nearing retirement, if you've got a lot in your IRA and there's a period of time when you'll have lower income, that's the time to consider converting some of that to a Roth. And the benefit of a Roth is that the income and growth on the Roth account are tax-free forever. So if you think of a beneficiary, think back to that 10-year-old beneficiary we talked about earlier. Let's call him Johnny. So if Johnny got the IRA funds, that was $414,000 in IRA funds through a typical IRA. It was I can't remember the number, 3 point some million dollars after tax at today's rates. However, if you remember that number for pre-tax, that's what they would get with a Roth, that 5 point whatever million. So another $1.5 million over their lifetime, roughly, by doing that Roth conversion. Again, it does require some sacrifice now, but it would produce a great benefit for ever. And that's something to talk about with a financial advisor to see if a Roth conversion is something you'd want to do to fit within your plans. So what does planning with an IRA preservation trust do for you? Well, it gives you a huge way, a way to give a huge legacy for you, your spouse, and your family. It helps defer taxes over a much longer period of time. These taxes, if you have deferred RMDs for your lifetime and you leave it to a grandchild, these taxes could be deferred for 40, 50, 60, 70 years. And it protects the legacy for those you love even after you're gone by wrapping it in this asset protection language, by including provisions that would protect it from a spendthrift, that would protect all of the funds from being taken out at once. And then you can carry your own lifetime plan into the next generation. It's not just for you and your spouse, but for others, your grandchildren, your children. And this type of planning, and that gets into the first question that I have is, who would use one of these? And typically it's going to be someone who does not plan to use all of their retirement funds in retirement. If you've got other investments or pension or other things to live on, if you have a goal to live only on the RMDs plus your Social Security, then this is when your plan would work best for you. Is sorry, I'm just reading some more questions here. Is the plan would work best if you are using it as part of a bigger estate planning um, program. So if you have other assets that you're going to leave to different people and you want to create a special house, so to speak, for your retirement assets and maximize the benefit and the duration, the IRA trust is for you. And now the other question I have here, how much does the IRA have to have for this type of planning to make sense? It really depends on the client, and we'll talk through that in a consultation. So you can call and set up a free consultation where we'll go through all of this. But a lot of times an older person could have maybe $250,000 that is saved. And some of these examples that we had in this slide presentation showed what $100,000 would look like, what $300,000 would look like. Typically, if people are going to be doing some planning, we like to have it at least around that $250,000 mark for us to think that the numbers make sense, because you're going to have administrative expenses and whatnot. There's going to be tax returns that have to be filed, not while you're alive, but after you're gone. And we would run through what expenses your children or grandchildren or other beneficiaries may have to see if it makes sense um, for that. We've had people who have had less than 250,000. We've had people that have had significantly more. And I think the more that's there, the more likely it is going to make sense. And if you're planning for 10, 15 years and wanting to have this trust in place, then it's going to continue to grow. If you're taking RMDs or whether you're not taking RMDs, if we're looking at someone who's 70 and a half and they're looking at 10 more years of life expectancy and they want to make sure that the family is taken care of, or maybe we're talking to somebody who's been diagnosed with a terminal illness and they know that their time is short, we may look at smaller amounts than that $250,000 number, just because maybe they've got younger children or grandchildren that they want to take care of with these IRA funds. And this is a way that makes sense for them to do that. All right. We're coming up on an hour. I planned on about an hour of, or a half hour of presentation time and up to a half hour of questions. So if anybody needs to hop off the call, that's fine. Feel free again to email questions to info@eyestoneLawOffices.com, or if you want to set up a consultation, the number to reach us. My assistant is 616-777-5293. Again, 616-777-5293. And I don't think I did a good job of explaining of the revocable nature of this trust, simply because some of the questions are coming in. Can I change the beneficiaries? Can I change the trustee? These trusts, and can I change what can I change what IRA goes into this trust. This trust is, like I said before, it's like a beneficiary designation on steroids. This trust doesn't do anything really until after you're gone, and if it's planning for you and your spouse, not until after both you and your spouse are gone. So yes, you would be able to change the beneficiaries. Yes, you'd be able to change who holds the IRA, because this is just the uh, IRA designation. This is where your IRAs would go. You would need to coordinate to make sure that if you did move the IRA to a new account um, manager, a new financial advisor, or a new brokerage firm, or whoever, that the new beneficiary designations were done correctly. And that would allow you to keep the trust that you've already done and really move things around. And changing beneficiaries is just as easy as changing the trust language. And typically we use some pretty expansive language when we draft these trusts so that it includes everybody that it can possibly include as of the date of your death. So if you are planning for your grandchildren, it will include all of the grandchildren that are living as of the date of your death. And it will use their joint lifetime or their life expectancies to determine what the required minimum distributions are and how long of a stretch that each of them will get. And lastly, yeah, changing the trustee. It's a revocable trust. We have what's called our Infinite Legacy Program, and members of our Infinite Legacy Program meet with us on an annual basis, and we do review beneficiary designations, trustee designations, financial advisor relationships to make sure that all of those are running on all 8 cylinders or 4 cylinders or however many cylinders you have to be running on. And that would be part of the process we would include in our Infinite Legacy program, making those changes to beneficiary designations or beneficiaries or trustees. We call those typographical changes, and that would be included as part of our annual review to make sure everybody's included and everybody understands what's going on with this program. And again, with these IRAs becoming such huge assets, people have, 1 or 2 children and they've got $1 million or $1.5 million or a $500,000 or whatever amount in these IRAs, and they're leaving them to children who don't quite understand how IRAs work, or they don't understand what the best way to get these funds are. There is plenty of potential for these children to not understand and to have things forced down their throat. And the one area that I've seen over and over again is when these beneficiaries call and say, hey, I am the beneficiary of this account. How do I get my inheritance from these accounts? And for a lot of the company plans, they just get a check in response. There is not an option to do anything else. For um, other companies that we've dealt with, there is a requirement that the beneficiary fill out a form, and when these folks are going through the grieving process, they a lot of times will go with the simplest route. So there's going to be a box that says, give me my funds now, check the box. That's the easiest thing to do, so that's what they do, without thinking that, oh my goodness, I am giving up an extra 20 or 30% of my inheritance to taxes, or I am now commingling this with my spouse and things haven't been going well with my spouse and I. And all of these things come to being because it's not a great situation when you're a beneficiary of something. Somebody that you've loved has died, and you're just trying to go through mounds and mounds of paperwork. And I think that this IRA trust is a way to slow that process down, to have somebody specifically appointed who's going to be in charge of that, who's going to be educated through our Infinite Legacy program, and will understand what their roles and duties are as the trustee and what the best way to handle that with the financial advisor or other firm who's involved with the payout after the death, to make sure that it is treated um, as a stretch and gets the best tax treatment. Well, I've rambled on here for about an hour. I appreciate those of you who are on the call. I appreciate those of you who are taking the time to listen to the recording. We are coming up on an hour right now, and I don't have anybody that is raising their hand, so let me um, unmute everyone here and see. I'm going to unmute everyone here. If you have any questions, speak up. I'm going to give it about 5 seconds. All right, so everybody should be unmuted right now. So speak now or forever hold your peace. Thank you for spending your Sunday evening with me, or whatever evening you choose to listen to the recording, if that's how you choose to do so. Again, if you have any questions about this presentation or any of the things that I've talked about, feel free to set up an initial consultation for a review of how this works. My assistance number is area code 616-777-5293. Again, 616-777-5293. Folks over in the Muskegon area, we have a local number, 683-1000, if you'd like to use that. Again, 683-1000. And we are coming right up on an hour, so I'm going to end the call. I'm going to mute everyone, and have a great night. Thank you again. Goodbye.